Hello everyone, my name is Ming. I've been invited to testify the Substitution Bill 5271. I think the first of all, the first question is whether the health practitioners act in good faith following the guidelines, recommendation, and instruction by the federal, state, or local authority regarding to the COVID-19 pandemic, and um, the second question is if the court should consider whether the harm was caused by inadequate resources due to the COVID-19 pandemic. The guidelines apply only to determine whether health practitioners provided to require standard of care during the pandemic. Mm, the Substitution Act Bill 5271, I think it should be upheld by the Washington State Legislature. First, uh, the Act exempts healthcare workers from full responsibility during the pandemic, and as is little as known that about that the COVID-19 and the treatments are changing as healthcare workers learn more about it. This is a new virus, and there's no set plan or treatment at that time. As a result, there are no clear guidelines for at the time when a person cannot, in accordance with standard nursing practice, acts that promote limited liability are good because they encourage healthcare workers to work effectively without fear of liabilities. And Washington is one of the few states that does not exempt medical liability in medical practice. And the passage of this bill will improve their working conditions and the quality of the healthcare uh, that they provide. Second, the non-emergency service should not be given priority during a pandemic in order to maximize the use of resources. Washington states the governor suspends non-emergency procedures while it is not clear which process and agreement are non-urgent. Some are obvious. For example, the checkup, the examination, health maintenance, and general screening are not emergency procedures, and people can do it without them during the pandemic. And non-emergency procedures diverted the resources and that could have been used to respond to the pandemic. Um, Ordered by the governors and passed legislatures ensure that doctors are not liable for decision made in good faith during pandemic because it was the governor's order, and if the bill passed, the responsibility lied with the state and not the medical practitioners. This is an advantage to the health practitioners because they can work in this unprecedented era without fear of responsibility. And the Washington State Medical Association and the Washington State Hospital Association also agree on the responsibility of healthcare workers. And and the Washington State should follow suit in steps already taken by the national government and other states to protect the medical practitioners against liability during the pandemic. The United States Department of Health and Human Science are demanding that the public readiness and emergency practice to protect the healthcare workers dealing with the COVID-19 pandemic, and also the CARE Act signed by President uh, Donald Trump administration in March 2020. It protected healthcare workers dealing with the pandemic from federal liability protection. And other states like New York also follow the suit. Washington State should follow the practice as it protect their professionals, healthcare workers. However, there are a few disadvantages of this bill. and there's no classification of emergent and non-emergent health issues. All matter to do with health are serious, and none should be prioritized above the other. A single checkup will make a big difference in a person's health as opposite to no checkup, as much as COVID-19. Um, so so do um, so delayed screenings or diagnosis and maintenance leave patients vulnerable and even worse. The medical practitioners are not held liable. In addition, the bill discourages people from seeking healthcare as it is. The people are afraid of visiting hospital in in for year of contracting the COVID-19. When the bill practically exempt doctors from liabilities, people became even more um, skeptical about going to the hospital, while avoiding avoiding the malpractice cases. The medical practitioner may end up not diagnosing people at all. Um, in conclusion, medical practice is undergoing many changes at a very high rate during the pandemic. Agreements change rapidly, and it is difficult to track them. What is malfeasance and what is not. Therefore, in order to ensure that healthcare workers do not have to fear liabilities for circumstances beyond their control, uh, such as, for example, like pandemic. Uh, when providing service, the Senate, the SSB 5271 replacement bill should be enacted, and the bill does not exempt doctors from all liabilities. On the other hand, it can protect them during a pandemic when there are no clear guidelines on how to respond. Most important, most importantly, it allows the medical practitioner to prioritize the emergency service over the non-emergent service. In that way, resources and supplies and facilities can be used more efficiently and to fight the virus and restore normalcy. Access to the healthcare, even for non-emergency care, is an integral part of maintaining a health, healthy population. However, we need to do everything possible to combat the COVID-19 pandemic. That's all my testimony and my consideration. I hope those arguments and also the memo will help. Thank you so much.